Hello, this is Jeff Kelly. Have you received a Social Security Overpayment Notice? Can bankruptcy stop the clawback? And the answer to this question, like most legal questions, is it depends. So, if you just received a letter from the Social Security Administration saying you have been overpaid, do not ignore this notice and do not assume you're trapped. Under the Social Security Administration's current rules, if you do nothing, they generally have a 30-day period, but then they're going to start withholding if you don't do something. So for many Social Security overpayments established on or after April 25th, 2025, the default withholding rate is 50%. Holy cow, of the monthly benefit. For SSI, the agency's public guidance says the default rate is 10% of the monthly payment. Okay, this matters. A 50% reduction in your Social Security check is not some little small bookkeeping issue. For a lot of people, this is grocery money, medicine money, gas money, utility money, rent. So the real question is not just, did I get an overpayment notice? The real question is, what's the fastest and smartest way to stop this damage? Okay, here's the plain English answer to the title of this video is yes, bankruptcy can sometimes stop the clawback, and in some cases, it can do more than that. But let's focus on something here. If real fraud has been committed, we need to know, because fraud is not dischargeable in bankruptcy. So what is an example of like real fraud, and what would be an example of maybe we could wipe it out? So let's say you lied about like how much you make, you didn't report income, and now the Social Security Administration is saying, hey, we overpaid you, and now we're going to take it back. That might be, that's pretty hardcore fraud. I don't think you're going to be able to wipe that out, but we might be able to pay it back in a Chapter 13. It might be beneficial to consider filing bankruptcy to get rid of other debts like credit card debt and medical bills so that you can focus on paying the overpayment back. But let's go into a little more detail here. So before you even get to bankruptcy, you need to understand there are three separate fights here. Fight number one is whether the Social Security is even right that you were overpaid. And fight number two is whether, even if the overpayment has happened, you should have to pay it back. And fight number three is whether, if you do have to pay it back, does the withholding amount need to be reduced? And a lot of people lump all of that together, and that's a mistake. There are different remedies, and picking the wrong one can waste a lot of time and money. So let's start with the first one. If Social Security is wrong on the facts and wrong on the amount, you can request reconsideration. Maybe you don't have to file bankruptcy. And this is important because, as a general rule, your Social Security check is, creditors can't go after that. They can't garnish you. They can't garnish your Social Security check. It's a protected stream. So most of the time when somebody calls me and says, hey, my sole source of income is Social Security and I want to file bankruptcy, the vast majority of the time, I'm going to tell them, hey, don't file. It's just not worth it unless there's some asset you're trying to protect or something along those lines. So the Social Security Administration says that a reconsideration request can be made when you dispute the fact or the amount of the overpayment, and it generally must be made in writing within 60 days of the date of the initial overpayment notice. So that is a route when your position is, I was not overpaid, the amount is wrong. And timing does matter. The Social Security Administration's current public guidance says if you ask for an appeal or waiver within 30 days, they will not collect the money until they decide your request. And that's a big deal, because if you just sit on the letter, you may let the withholding machine start rolling. But if you act quickly, you may stop that from happening while the challenge is still pending. Second, maybe the overpayment is real, but you should not have to pay it back. That is where a waiver comes in. The Social Security Administration says you can request a waiver if you cannot afford the repayment and you believe overpayment was not your fault or that the repayment would be unfair. The Social Security Administration's materials also say you can request a waiver at any time, even after the recovery has started. And if the overpayment is $2,000 or less, the agency may be able to process the request by phone instead of requiring the full form. Third, you may not be fighting the overpayment itself, and you're not really asking for a full waiver. Maybe you're saying, I can't survive if you take this much out of my check every month. The Social Security Administration has a separate form for that, SSA-634, Request for a Change in Overpayment Recovery Rate. You can download this, fill this out, get this to the Social Security Administration if this is your best option. The Social Security Administration says you use that when you want the current withholding rate adjusted because you cannot meet your necessary living expenses to pay for food, to pay for gas, to pay for getting by. This is not the same thing as an appeal, and it's not the same thing as a waiver. Now, let's get to bankruptcy, because that's the part most people want to know about usually in this video here. So bankruptcy, we don't want to go this route unless we have to, unless it's going to make sense. And so to know that, you're going to need to meet with a bankruptcy attorney, go through all the monthly income, go through the assets, and we're going to know, hey, is it fraud? Is it not? Or is this like some accident? Let's assume that it's truly not fraud and it truly is just an accident. We may be able to wipe out all of that overpayment as an unsecured debt, because that's what it is. It is an unsecured debt. So bankruptcy may be a good option for you. You won't know until you explore the option and go through all of the steps. Now, let's say for whatever reason you need to file a Chapter 13, Chapter 7, that's where we wipe everything out. That's the fresh start provision. In court, out of court, bang, credit card, medical bills, all that stuff is wiped out. But what if you need to do a Chapter 13 because you've got a house with a whole lot of equity, there's something we're trying to protect, maybe there's a car that we're worried about might get repossessed. It might make sense to do a 13 in some cases. And in a Chapter 13, the Social Security Administration says that if the court approves the plan and the trustee pays the creditors according to the plan, a lot of times we will eliminate debt in a Chapter 13 the same way we do in a Chapter 7. So this may be a good path. The key is to get to the finish line and get a discharge so everything's wiped out. But here's where some people mess up a little bit. Bankruptcy is not a magic bullet. It's not a free pass for fraud. And the Social Security Administration procedure says that, hey, if they think there's some bad fraud here, they're going to refer it to their Office of General Counsel, and they're going to object to either your Chapter 7 discharge, or they can also object to a Chapter 13 discharge when the overpayment comes from full-blown fraud and misrepresentation. So again, examples include failure to report work activity, making false statements while the benefits keep coming in. And the Social Security Administration's current financial reporting also says that fraud-related overpayments can be subject to 100% withholding instead of the normal default rate. So if the overpayment is tied to actual fraud or intentional deception, do not just assume that bankruptcy is going to just make it vanish. So the right answer is not just some knee-jerk reaction. It's not always file bankruptcy, and it's not never file bankruptcy. The right answer depends on the kind of overpayment, how it happened, whether there's a real factual dispute, whether the waiver is viable, whether a reduced payment will solve the problem, whether other debts exist, and whether there's any fraud sitting in the background. So here's a simple example. Let's say a retiree gets a notice saying that Social Security has overpaid them $18,000 because of an earnings issue or some benefits calculation problem. Well, let's say it's a benefits calculation problem, because that's the Social Security Administration's fault, not yours. I like that one the best. So let's also assume they've got $40,000 of credit card debt. For this person, it really might make sense to file a Chapter 7, because in this example, we're going to get rid of $58,000 of unsecured debt. Bang, boom. This could be a good stress relief. Now let's take a different example. Let's say the overpayment happened because the person knowingly kept working, never reported it, even though they understood they had to. That case is much more dangerous. In this case, we're not wiping out any Social Security overpayment debt because it's based on fraud. So that's the kind of case where, we don't want to guess our way through it. We need to come up with a plan to pay it back. And we could do that through a Chapter 13, but you might want to explore working something out directly with the Social Security Administration first to see if they're going to be reasonable and see if they're going to be able to do it in a way that you can live and survive. Okay, so what if you're no longer receiving Social Security benefits and you're now back at work and you think you're safe? The Social Security Administration's public guidance says if you're no longer receiving benefits, it may still collect in other ways, including withholding tax refunds, certain state payments, or they may turn around and try to garnish your wages. Its financial reports also describe Treasury offset program collections and administrative wage garnishment. So ignoring their letters is not a good strategy. In fact, it's a bad strategy. It's crazy that there are, some ostriches who will bury their head in the sand, and an ostrich may be able to get away with it, but you can't. Don't do it. It's a bad idea. The problem won't go away by itself. So here's the bottom line. If you got a Social Security Overpayment Notice, you need to ask 4 questions right away. First, is the Social Security office wrong on the facts or the amount? Second, even if the overpayment happened, do you qualify for a waiver because it wasn't your fault? And repayment could cause hardship or be unfair. Third, do you need the repayment amount reduced right now? And fourth, is this part of a larger debt problem where bankruptcy might be the best overall solution because you got all this other crap hanging over your head anyway? So these are not academic questions. They decide whether you keep your check, lose half your check, or put the whole problem into a strategy of, hey, let's get a fresh start. So if you live in the state of Georgia, go to my website, www.kelliganhelp.com. I've got a free book and you can download a copy of it. If you don't like to read, you can listen to it because I have an audio version as well. I also have a version in Spanish if you are a Spanish speaker. So if you've got questions, don't hesitate to give us a call. It's a free consultation. It doesn't cost anything just to talk to us. Thank you so much for tuning in.